Welcome to Guns, Gear, and Guns with Gary Gunderson. I am Gary Gunderson. A federal judge vacated the ATF's rule that redefined incomplete receivers and frames as firearms. This was the Biden administration's attempt to stop those spooky, scary ghost guns, such as this Polymer 80, which I built. Ooh. The rule changed the definition of frames and receivers to include parts that are not yet frames and receivers, even though they aren't the thing. The court disagreed with this rule, stating that the ATF exceeded its statutory authority. The judge correctly pointed out that they did not simply update the terms for changes in technology or new innovation, but also imposed regulation on partial frames and receivers so that 80% frames and receivers, for example, are now considered firearms, requiring them to go through a background check and a federal firearms license and be serialized. Furthermore, the rule did not define at what point between an unmachined block of metal or plastic and a fully built frame and receiver is frame hood or receiver hood magically bestowed. So there was no way to put something out that's at all partially made. The government argued that the defendants had no cause in this case because there was no injury. Having to pay $30 to their FFL to transfer an incomplete receiver is not the fault of the rule, which of course is absurd. The judge rightly points out that this is an obvious result from this rule. The judge does limit the ruling insofar as he declined to rule on the constitutional question of the ATF's bureaucratic powers, as there was no need to examine the question, since in this case they clearly exceeded their authority. The decision points out that parts that may become frames or receivers are not, in fact, frames or receivers. Clearly, Congress defined these terms in the law, and if they wanted to define it differently, they could have done so. Since they did not, they clearly did not intend to regulate them. Even pointing out that in a different part of the Gun Control Act, there is language included in regards to weapons that may be readily converted. The fact that they did not include this language in regards to frames and receivers is a clear indication of their intent. The ATF actually argued that leaves the precise definition of that term to the discretion and expertise of the ATF, even though they already defined it in the text of the law. I cannot believe their lawyers argued that, but I guess they probably knew they did not have a leg to stand on otherwise. The judge points out that when the ATF previously defined frames and receivers, their definition was in line with commonly accepted definitions, and that this mess of a document does not conform with common definitions at all. The ATF cannot say that something that is not operable as a receiver is still a receiver. As the judge wrote, logic dictates that a part cannot be both not yet a receiver and receiver at the same time. The ATF argued, and this is my favorite part, that since they have a history of agency action via letters determining what is and is not a firearm, this is proof of their statutory authority to do so. To which the judge responded, if these administrative records show that ATF has previously regulated components that are not yet frames or receivers, but could readily be converted into such items, then the historical practice does nothing more than confirm that the agency has, perhaps in multiple specific instances over several decades, exceeded the lawful bounds of its statutory jurisdiction, which is hilarious. The ATF's argument was, hey, we do this all the time. We've done it for years. To which the judge said, oh, really? So you've been acting outside your authority for decades? The ATF also argued that this is necessary. Otherwise, people will be going out and buying incomplete frames and receivers and completing them, which was against Congress's goal for firearms law, and the judge essentially says, If they intended to regulate firearms in this way, it would have done so in the law. The judge continues laying into this rule by saying that their new definition of a firearm, which includes part kits that can be readily converted into a firearm, directly contradicts the definition in the original law. Not a clarification, literally includes the opposite thing as defined in the law. Precise wording demands precise application, which is a good summary to how laws should work. Having a bureaucratic agency redefine keywords in a law makes all laws a joke. This could apply to some other court cases that are currently ongoing as well. In deciding to vacate the rule completely as opposed to returning it to the agency to alter or justify, the judge determined that since they exceeded their authority, there is nothing to justify, and that is not a big deal because it just returns things to the status quo. The judge could have granted a smaller injunction to the specific parties, as we have seen with the brace rules lately, but decided that vacating the rule altogether is more appropriate. But what does this mean going forward? Are you just able to get 80% now willy-nilly? Well, the government will have the opportunity to appeal and also will probably try to get a stay on this so that this unconstitutional rule stays in place. So this will likely still be in effect for a while. I find it unlikely that they would simply let the rule die at this point, though there's a chance they might if they think taking it to a higher court may lead to the Supreme Court, which could result in an answer on the constitutional question and potentially end the ATF's rule-making authority altogether. But that's probably hoping for too much. What do you think will happen? Will the rule be allowed to die? Should 80% be regulated? No. Let me know in the comments below. Please join our public Discord. If you think the ATF is exceeding their authority, hit the like button. Don't forget to subscribe to the channel and share the video to help the channel grow. Thanks for watching.